Good afternoon to everyone. We want to welcome you to the Tennessee Court of Appeals. I'm Judge John McClarty, the presiding judge for this session. To my right is Judge McBrayer. To my left is Judge Ushman. As you present your cases, I think, as you already know, each party will be presented with, will be allowed 15 minutes. The appellant has a right to request for rebuttal, and within those 15 minutes, and we will allow up to 7 minutes for rebuttal. Okay. Is there any matters to come before the court, preliminary matters, Madam Clerk? And in that case, we ask that you please call the first case.
Kristen Elise Turner, deceased by and through her natural parents, Anna Marie Turner et al. First, Charles Brent Boles, MD.
Good afternoon.
Yes, sir.
I am Joe Bednars, Senior of the Nashville Bar, and along with my son Joe Jr., we represent the appellant. We also represented the plaintiff in the trial court. I would like to reserve 4 minutes for rebuttal.
You may.
My client, Kristen Turner, was born with a fractured skull. Everyone agreed, or all of the experts agreed, that this fractured skull occurred at or around the time of birth. There was no dispute about that. As medical malpractice cases go, I think this was a relatively straightforward case. What caused the skull fracture? It was really that simple. It was kind of a simple issue with complicated medicine going around it. The plaintiff experts, we had 2 experts on the issue of liability and causation. A Dr. Bruce Bryan, obstetrician from St. Louis, and Dr. Thompson, a pathologist, a pediatric pathologist that does autopsies in Louisville, Kentucky. They were both of the opinion that this skull fracture occurred at the time that Dr. Boles went in to do a vaginal exam, discovered that the baby was OP, which is face side up. And then he attempted to turn the baby with his hands. According to his own estimate, this occurred between 6:30 and 6:52. I don't know how many minutes he was trying to turn that baby, but he was not successful. The father, Nick Turner, was standing there watching him, and he testified that Dr. Boles was using so much force that it looked like a person squeezing a coconut. And he said he was cringing just watching the doctor do that. Then all of a sudden, the doctor has an moment of something, because he stands up, walks out of the room without saying anything to the parents. Nothing. Comes back in 15 seconds later and says, "We're doing an emergency C-section," without any explanation, without any discussion about the pros and cons. We respectfully submit, and we did at the trial court, that this is when the skull fracture occurred. At the time he was trying to turn that baby, he was unsuccessful, and that was our position.
Counsel, you say you have 2 experts on liability and causation. I thought Dr. Thompson was limited to causation, though.
Yes, I might have misspoke. We had 2 on the issues of, one was, Dr. Bryan was on both.
But Dr. Thompson was limited just to causation.
Limited to causation, yes.
Counsel, given the jury found in this case that there was, do you find by preponderance of the evidence that Dr. Boles violated the standard of acceptable professional practice, and they concluded that he did not, where is the harm with regard to the exclusion of this testimony and evidence by Dr. Thompson? I mean, you have various pieces of testimony and evidence through Dr. Thompson that you're saying it was error to exclude, how the trial court handled it, but we don't get to causation in this case, do we?
Okay. Well, you know, most of the errors that we complain of involve causation. And in most cases, Judge, you're right. Most cases, the jury would come and answer the first question, did he violate the standard of care? If they say no, then that's it. The case is over. There's no sense in going to causation. But in this case, you can't do that because the whole issue was our experts said that Dr. Boles used excessive force in turning. That was both that was the negligence, the excessive force in turning. So in this case, causation and standard of care are actually one and the same. You really can't separate the two.
But your jury form, though, provided that if you found no breach of standard of care, that you're to stop there. So it sounds like you're arguing that there was an issue with the jury form then.
No, I'm not. But the jury would have to find causation before they could find standard of care. And maybe in this case, maybe we should have had it listed first. I don't know that there's any rule that says one has to be determined before the other, but it's always standard of care.
Well, wouldn't the statute, though, dictate that that's the way, the progression of a healthcare liability case?
I'm not sure of that, Judge. But I think when you look at the issue and what the experts testify to, excessive force at the time of turning, and if and it's one and the same. I mean, that was the cause of the skull fracture, and that's what Dr. Thompson was addressing. But I respectfully submit that they, in this case, they're one and the same, and just because they didn't get past standard of care doesn't mean.
Was there any objection made to the verdict form here?
Not on this issue, no. No, none at all, Judge. Now, the first error that I'd like to discuss is we raised 5 issues on appeal. We filed a motion in limine to keep medical literature out of the case pursuant to Tennessee Rules of Evidence 618. The judge denied that motion. And the constant theme of the defense was no one has ever, and I'm quoting now, no one has ever seen, heard, or read about this happening. No one has ever seen, heard, or read about this happening. Therefore, it doesn't happen. This doesn't happen. You can't injure a child during this turning. And we heard that over 40 times. We did the word search. Over 40 times this was echoed throughout the trial. Doctor, have you ever seen, heard, or read about it happening? No, there's no literature. So this was a constant theme. First of all, that would be irrelevant, whether or not there was any literature. You can't use it anyway. Just like, let's say there was literature that said, be careful, you can fracture a skull by turning it. Let's say there were 5 cases reported. Would that be admissible? No. Would that mean Dr. Boles then fractured his skull while turning? No. It has absolutely no relevance whatsoever. But it was throughout the trial, that's all you heard. There's no literature. It doesn't happen.
And would the fact that was attempting to brief who be proved here with respect to absence of literature, also go to the causation issue then?
Oh, yes, for sure. And, but we objected just continuously. And in our brief, we submitted a lot of authority, talked about Darbert, and this is, I think this is a first impression type thing for the courts. If the court doesn't address this issue, we're going to see it at all of these trials over and over and over. 618 is clear. You can't use literature as substantive proof. This was such a clear violation, it's mind-boggling how we could have gone through a whole trial with repeated irrelevant evidence. The cumulative effect of it throughout the trial was devastating. I can tell you from doing this a long time, literature makes a difference to juries. You always have experts on the plaintiff's side, experts on the defense side. They're always opposite. And when we're fortunate enough to be able to cross-examine one of them with literature, it makes a big difference. Literature matters because it offsets this bias. And in this case, we had a constant parade of it that was just almost impossible to overcome. And but I guess you repeat something over and over and over, and eventually it sinks in. But we were very much prejudiced with that constant theme throughout the case.
And would your conception of the rule or understanding the rule be that if you had an expert witness on the stand and you desired to cross-examine them, an area of a permissional area of inquiry would not be to ask the expert, there's no literature on this particular subject?
I think you might be able to ask that question. Have you seen any literature? But not when the way it is used to prove a fact. In the argument, in opening, in closing, that's all we heard. And that was the argument.
And you would suggest the fact here that the defense was trying to establish was that there would never been a circumstance in the past where the attempt to reposition a child caused a skull fracture.
Well, it's our position that it has happened, and as stated.
Well, I'm saying, I'm looking, you're putting on the defense position
yes.
here, and the harm that you're saying it's caused your case, your argument would be that related to causation as well.
Oh, yes, absolutely, absolutely. The next grounds am I almost out of time?
You're out. It's time.
Okay.
You do have your rebuttal time, though.
Okay, that's fine.
Good afternoon, Your Honors. I'm Dixie Cooper here on behalf of Dr. Brent Boles. I'm going to stick to my outline, even though some of the questioning and some of the discussion that's already happened is going to make it a little bit repetitive. But I want to make sure I cover the things that I think are important for the record. First thing that I think should be addressed prior to responding to some of the specific statements that Mr. Bednar has just made is to identify the issues and arguments raised in plaintiff's brief that are related to causation and not standard of care. As the court knows, this Rutherford County jury heard the evidence in the case for a couple weeks. They deliberated, returning with a unanimous verdict in favor of Dr. Boles, finding he did not violate the standard of care applicable to him in the care of Ms. Turner and her baby. When that happens, as reflected in the jury verdict form, when there is no deviation, the law in Tennessee says you stop there, because if you have no deviation, you don't get to causation under the law. And so when they stop with no deviation from the standard of care, the causation component becomes moot under the law. As Your Honor suggested, there is a statute. There's statutory language that governs these healthcare liability cases. You've got to establish what the standard of care is that applies to the doctor in his community and/or specialty. You've got to establish that he or she deviated from the standard of care. and then that it caused an outcome which would not otherwise have occurred. So the way the jury verdict form was put together, by agreement of the parties, with no objection by plaintiff's counsel to the order in which it was set, which is routine, the routine way it's done, in my experience, we don't get to causation. And the bulk of the plaintiff's argument in their very lengthy brief addresses causation. If there is no causation to be determined, any potential error that they allege occurred as part of Dr. Thompson's testimony, what he was and wasn't allowed to say because he was strictly a causation expert, is moot. It's irrelevant. The plaintiff's brief, on page 2 of their brief, they identified 3 of the 5 categories that they listed on page 2 of their brief. 3 of the 5 categories are causation issues only. The first one relates to Dr. Thompson, who's a causation-only expert, and the exclusion of opinions that were identified very late in the game. Actually, they were partially identified in a deposition. The disclosure that was provided on behalf of Dr. Thompson had 2 opinions in it. One is Dr. Thompson is going to testify that he agrees with the autopsy report. It doesn't say he agrees with the autopsy report, but he wants to add some things or expound or expand. It simply says he's going to agree with the autopsy report. The second opinion wasn't an independent opinion that Dr. Thompson came to. It said he's going to offer the testimony that Dr. Bryan's opinion that pressure from a head rotation of this child caused her death. He's going to testify it is consistent with what he has read. He doesn't say, to a reasonable degree of medical probability, it was this. In fact, there are points in the transcript where he says, I'm not saying this is the manual rotation. But in any event, those are what he was disclosed on. That's it. 2 sentences total. And it's not until I get to his deposition much later, with some difficulties getting it scheduled, just less than 2 months before the trial, that we get a series of other opinions that are wholly unrelated, wholly missing from his disclosure. So those opinions were all excluded because plaintiff's counsel did the disclosures in February of 2023. The deposition wasn't taken until August of 2023. In that intervening period, slides were provided to this doctor, opinions were created, and letters, emails extended saying we've got to get these disclosures supplemented. Never happened. Never happened. Not ever. At no time during the entirety of this case and all the proceedings we had with the trial judge did plaintiff's counsel ever comply with Rule 26 that says you must seasonably supplement a disclosure if it doesn't contain all your opinions. Now, experts can look at materials and see things that they want to comment on, and they can...
Beyond the 2 sentences in the Rule 26 disclosure, there wasn't an expert report of any type appended?
Not Dr. Thompson. Dr. Bryan produced a report that I believe was done, it was an affidavit and a report that were done early on in the case. I think the affidavit might have been to prevent our motion for summary judgment. But Dr. Thomas never prepared a document himself. This was prepared by plaintiff's counsel. So that's the first category that plaintiff's counsel says is error. That's nothing but causation testimony because it's all about Dr. Thompson.
Okay, could we hop into, you identify 3 of the 5 issues.
Yes.
Let's hop to issue 4 then.
Okay, so at absence of literature you all talked about, the one thing that I do want to say about the literature as it came up in this discussion is Mr. Bednarz is misinterpreting what Tennessee Rule of Evidence 618 is. 618 governs how you use medical literature, and you can only use it in a limited fashion. So a piece of medical literature is hearsay. It's classic hearsay, out-of-court statements, offer for the truth. So you can't use it in direct exam. You can't have an expert sit up there and read an article. 618 prohibits that because there's no way you can cross-examine an article. But you can if you get an expert to say that a piece of literature is reliable or authoritative. You can then use that against another expert to impeach his or her testimony. Rule 618 says nothing about the absence of literature. And for the record, the reason we talked about in front of this jury and with Dr. Bryan, the plaintiff's only standard of care expert, about the lack of literature goes to his credibility. The credibility of the statement he is making to this jury, which is this manual rotation of the head is what caused this child's injury, instead of the identified in autopsy report finding of cephalopelvic disproportion. It basically is a big word for saying cephalo is the head, pelvic is the mom's body, and the head and the body aren't fitting in there correctly because there's a bony pelvis down there. And if the baby's head is turned the wrong way, or the baby's malpositioned, the baby's head, cephalic, that's what this is, can go up against that bone, and mom's pushing with vaginal labor, trying to get the baby out. The head can get up against the bony prominences on either side of mom and cause injury to the baby. So the purpose of no literature, which Dr. Bryan admitted and Dr. Thompson admitted, there is no literature they could locate to say that the mechanism of injury they want the jury to believe occurred actually
But I take it your first position on 618 is still the fact that, well, that goes to causation. And so we don't really need to
You're exactly
expound
right.
on 618.
You're exactly right. So you want to get to the two issues that I think are
Right.
relevant. Thank you. I apologize. So yes, those three items are all causation. The two that are left behind to consider are the court's exclusion of the consent order that was entered against Dr. Boles. It was actually by his agreement in 2023. The delivery was in 2016. He let his Tennessee license lapse because he moved to Florida to practice in 2022. But it's not until 2023 that the consent order actually comes into play. And it is a consent order related to his records that were being managed by a business, the records for his patients here in Tennessee. The records were being kept custody of by a business that did not provide those records to another patient, not Ms. Turner, to another patient who was asking it to get her medical records. So the consent order did not relate to Dr. Boles' competency to practice, how he manages labor and deliveries, or anything related to this case. It was simply an issue, an administrative issue that occurred where she did not get her records. She filed a complaint. Takes a little time to get through all those complaints that get filed. In 2023, because he's already let his license here expire, he's moved to Florida to practice, has no intent on returning, that he consented to it. But he never, ever denied that it happened. He never said, I didn't agree to a consent order, there was no consent order. So there is no credibility issue with regard to that consent order. That would be the one way a consent order related to medical records production to an unrelated client would have any probative value in a case like this. He never lied about it. He was never actually asked that specific question, but there is nowhere in this record that he lied or misrepresented what happened with regard to the consent order. And if there's no credibility issue, that consent order about giving records has no probative value, and the court properly excluded it. The other issue is the
Closing argument.
The closing argument, I'm glad you bring that up, but that's one of the other issues that involves just causation issues. So the closing argument, alleged misconduct, related to the autopsy report and what was written in the autopsy report, and the jury had that autopsy report. They had the autopsy report, they had the death certificate. Both of those documents talk about birth trauma. Birth trauma and cephalopelvic disproportion. And that cephalopelvic disproportion was the opinion that our client and our expert gave in the trial as what the birth trauma was that caused this child's injuries and her death. It's in the autopsy report. There was no misrepresentation of the autopsy report. That's what the misconduct claim was about, but it is a causation issue, what caused the child's injury. The other issue was related to something called peer review. If you've ever heard people talk about hospitals, they are set up with peer review systems in place to help ensure quality care. So when something happens outside general boundaries or measures that are set in place by the hospitals, it will trigger a review internally and potentially with outside help to say, did this doctor, did this nurse, did this individual do something that we want to see changed, that we want to correct? You have peer reviews where doctors determine not to be competent to do a specific type of procedure because he's had too many mistakes. But all the hospitals that I am familiar with do this peer review process. Now, the peer review process is designed to find things that happen, for example, in a labor and delivery, that didn't go the way they were supposed to go, and investigate it to determine, did the doctor do something that requires some corrective action, whether that's removal of privis, proctoring, or any sort of things like that. But again, that peer review issue related to the issue of, do doctors report or are bad outcomes actually reported? Dr. Bryan had testified, no doctor is going to tell anybody if they turned a baby's head wrong and cracked a skull. They're not going to tell you that. Well, that's not how it's done. It's done within the hospital peer review system, which their expert, Dr. Bryan, brought up during his direct examination. He's the one that brought up peer review. He talked about what his involvement was in peer review and how that works, and it's designed to help with safety and prevent incidences that are not good from happening prospectively. And I had Dr. Boles talk about his similar experience with peer review. But the peer review information, again, is related to the causation. Can this rotation of the head by Dr. Boles cause this kind of an injury? And so those two misconduct claims in the closing, autopsy report, the peer review that exist to help identify times when doctors or other healthcare providers do something that needs to be changed. And so it was not related to the standard of care. And then finally, we have the request for a special jury instruction on informed consent. Plaintiff actually pled a claim for informed consent in the complaint, but they never developed it through the testimony of their experts. The only expert who could address standard of care in terms of informed consent or malpractice, negligence, was Dr. Bryan. Dr. Bryan's disclosure never addressed informed consent. He never gave testimony in his deposition because the trial court actually read his deposition when this issue first came up. There's no evidence he talked about it in his deposition, so there was never an informed consent claim to be litigated. It wasn't litigated. There was never any testimony by any of the experts that there was an informed consent issue. The way it came up.
The consent form did come in at some point.
It did, Your Honor, but it came in because plaintiff's counsel, or plaintiff, Ms. Turner, was allowed to testify by the trial court over our objection that there was no litigated claim for lack of informed consent, nor any expert testimony offered on informed consent. We made that objection when Ms. Turner, either began or made the statement. The judge overruled us and allowed her to make her statement in front of the jury that she wasn't informed about the manual rotation. She should have been informed, or words to that effect. But it was never presented as a claim against Dr. Boles. It was simply her statement. And so informed consent, and because she made the statement and the court let her make the statement, we felt it necessary to put the consent form in the record. But you will see from the record, at no point did we ever argue or suggest that this consent form had anything to do with the underlying claim against Dr. Boles that he applied too much pressure when he was trying to turn the baby's head to get it delivered.
Thank you.
No discussion. Am I done?
You're done.
I hope I've answered all your questions. Thank you.
Thank you. Your rebuttal, sir?
Mr. Bednarz, can you start where counsel left off there? Was this an informed consent case?
No, it was not, Your Honor.
Okay.
Just real quickly, going back to the literature and the importance that this never seen, heard of, or read about, therefore it didn't happen. Ms. Cooper argued that strenuously in closing, and went so far as to say that these cases do get reported. And then she talked about peer review. And I believe all of you know peer review is protected. We can never get the peer review investigation. And to tell this jury, and she even used an example, like doctors used to turn with forceps, and they used to crush skulls, just like what happened to this kid. They quit using forceps, she said, because the peer review system worked and it was reported and all this other nonsense. It didn't come out of peer review. We've alleged misconduct on the part of Ms. Cooper, and rightfully so. Just because I didn't move for mistrial does not excuse her lying about the autopsy. It's clear, the autopsy.
But your own expert was prepared to testify that he agreed with the autopsy.
In general, he did not, well, the autopsy does not list cause of death as cephaloptic disproportion. That was only a clinical summary that briefly referred to the operative note in the medical records. The cause of death is clear, and it is not what she claimed it was. And that's what the problem. She was saying that the cause of death is what my experts have been telling you, cephaloptic pelvic disproportion. It's not true. It was a lie, and she knew it because she discussed it with our expert. And I believe in zealous advocacy, but you're not allowed to lie, outright lie, especially on a critical point like that. But anyway, I need to move on just a couple other things. Getting back to the standard of care and causation. I think when you look at it closely, you're going to see you can't separate the two. We had asked for a jury instruction. I believe that I'm not sure it's the latest recommended jury instruction, but instead of saying violation of standard of care and then causation, they lump it in one. And the question is the doctor at fault?
Counselor, aren't you drawing the distinction in terms of your disclosure between standard of care and causation? I mean, your expert witness disclosure says causation. It doesn't say standard of care and causation.
Yeah, as far as Dr.
Thompson is
concerned. Yeah, as far as Dr. Thompson is concerned.
Haven't you drawn that distinction in your own disclosure in this case?
Well, the disclosure, I'll tell you how simple that disclosure was. We said that Dr. Thompson will be offering causation testimony as to the cause of death of Kristen Turner. Generally, he agreed with the autopsy findings, but the autopsy findings did not conclude that this resulted from maneuvering the head. They didn't address that. They didn't know anything about it. So that was our opinion. That's what Dr. Bryan had in his opinions, and Dr. Thompson was agreeing.
So Dr. Thompson's testimony would have been that the autopsy is silent on cause.
On the cause of death, yes. Well, in terms of what the mechanism of the skull fracture is, it was silent on it.
Counsel, his testimony would not have been, though, that the head, for example, was turned too hard or squeezed too hard, and it's the squeezing caused it, not that it was too hard of a squeeze outside of the standard of care.
Well, the terminology from the experts was he used excessive force in trying to turn the baby. The baby wasn't moving, it was stuck, and he just kept on. And you can crush a skull. And the one thing Dr. Boles admitted when I asked him what caused this injury, He said one of three things: while I was turning the baby, or maternal forces of labor, or during the C-section. So it was disingenuous for them to say, oh, this can't happen. It don't happen. Well, it happened all the time with forceps, and it's happening now with the hand. By turning with the hand, you can crush your kid's skull, and that's what Dr. Thompson was trying to explain and give his reasoning for. And I respectfully submit he wasn't allowed to give his full opinions, and he should have been.
Thank you, sir.
Thank you.
That would be above and beyond our procedure. Your cases now has been submitted to this court for resolution. You should both receive our opinion and judgment within a reasonable period of time. At this point,